You're supposed to receive a companion probate file as well. We've not received that. Guardian. I would please. This is a motion to modify parenting time and request of a GAL. Mr. Walter is present. He's in pro per. Corey's are present. Is your name Patrick?
Good morning, Your Honor. Attorney Patrick Barry, PA.
Barry.
539.
Okay, thank you. We're going to be grabbing the guardianship file as well.
Understood, Your Honor.
Counsel, list your motion. You may proceed.
Thank you, Your Honor. The parties in this matter. Yes. Your Honor, we're here today on a motion on behalf of my clients. We're here to modify grandparenting time. We're asking for supervised period time for the defendant, and we're requesting a guardian in this matter. The parties in this matter have one minor child, age 9. My clients are grandparents of this child. As it currently stands, the last order was entered in June of 2022 and has attached as Exhibit A. The order is quite long, so I'll just get to the relevant part, which is where we're at now, Phase 8. In Phase 8, Your Honor, my clients are awarded parenting time or grandparenting time the second weekend of each month from Friday at 6 until Sunday at 6.
Okay, counsel, let me interrupt for a second. Phase 8 is the final phase, correct?
Yes, Your Honor.
Has it been completed?
No, Your Honor, has not.
If it's not been completed, then how is there standing to file a motion for grandparenting time?
Well, Your Honor, Phase 8 was never completed according to the schedule that the defendant was supposed to follow. He was supposed to have primary parenting time, but my clients have had primary parenting time since the order was entered.
Right, well, how does that fly with following case law, Straub versus Straub, Heltzel versus Heltzel, and Eldridge versus Ziny, Z-I-N-Y? There's no order yet.
Well, there is a grandparenting time order, Your Honor. There's an order for
there's a grandparenting time relative to the steps, but there's a provision in the order that once the order is perfected, then we can proceed accordingly. But the order has not been perfected yet. No one has filed a motion to perfect the order.
Well, Your Honor, I believe it was the defendant's responsibility to file a motion to perfect the order and ask for sole legal, sole physical custody. That never happened. And under the circumstances we're facing now, with my clients being the primary custodian, it's imperative that we file this motion with the court know what's going on for this child. We're in dire need of a guardian ad litem. We're in dire need of modifying the grandparenting time. Your Honor, could I go through the change of circumstance?
Just a moment.
Yes, sir.
Father does not have legal custody.
He does not.
Under the statute, to ask for grandparenting rights, there has to be a parent that has, the agreed parent has to have legal custody. We don't have that yet.
Okay. But the order executed in 2022, Your Honor, did grant my client's grandparenting time.
Correct.
Yes.
Correct. So this is really a parenting time motion.
Essentially,
at best, but again, the original order has not been perfected.
Right, Your Honor.
So hold on to that thought for just a second. If we're not, are we at we're not at the completion of all the phases then?
We should be, Your Honor, but no, the defendant hasn't completed all of the phases. I mean,
What are you alleging he's not completed yet?
Your Honor, he has to exercise his parenting time in accordance with Phase 8. I believe I granted him parenting time every weekend, Friday at 6 p.m. until Sunday at 6 p.m. with the midweek overnight. That never happened. And then after 2023, June of 2023, either party made motion in the court for perfection of custody of the minor child in the event Phase 8 is successfully completed. But it's been 3 years, Your Honor, and no action has been taken. My clients have been the primary custodian.
Right, under the guardianship.
Under the guardianship, yes, Your Honor.
Hold on to that thought for a second. Sir.
Yes, sir.
Actually, let me place all of you under oath. All three, raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Name is Jeremy Walter.
Yes, sir.
Mr. Walter, have you completed the steps in the order?
I have every weekend got my daughter from Friday at 6 to Sunday at 6. I haven't exercised the overnight during midweek because I'm currently in college. I have school. I have my other son that lives with me all the time. I'll admit, I thought that we were in agreement. Honestly, I had no idea that they were planning to even take me to court, Your Honor. I thought we had a good relationship. My mom was at my house February 9th, helping my daughters get ready for the daughter dance. And I sent pictures of her standing next to my daughter's bed. And these things they're saying against me are lies. I've had my daughter every weekend, and the only other thing that I haven't
So,
completed, one
Excuse
thing,
me,
I'm sorry,
excuse
go
me,
ahead.
Mr. Walters. So if there's a midday overnight, you're stating you've not completed it.
No, and also
Is that correct?
yes, sir. I have not done that. You're right.
Okay, so we haven't completed phases yet, it sounds like, unless there's a stipulation by the parties that they've completed it.
Well, no, Your Honor, there is no stipulation here. I don't think the parties here can come to any sort of agreement. It's just the fact of the matter is, I mean, if this motion has to be refiled as a grandparent time motion on the guardianship matter, we can do that. But Your Honor, this matter was filed in the family division, and the order was entered in the family division, granting my parents this grandparenting time. And again, I mean, they've been the primary custodians of this child. Mr. Walters is testifying that he's exercising parent time Friday through Sunday. That never happened. It's Friday through Saturday and occasional for next time Sunday, but that was rare, Your Honor.
Okay, why don't you go with your argument, and then if you want to establish testimony or bring forth testimony regarding whether the order has been, previous orders have been complied with, you may do so.
I understand, Your Honor.
Go ahead, sir.
Thank you, Judge. So, Your Honor, since the entry of the last judgment, there's been proper cause for change of circumstances as follows. The child hasn't had a proper bed at defendant's residence since spring of 2024, and essentially has been sleeping in a wooden box on the floor. We have that attached as Exhibit B in my motion, Your Honor. The defendant admitted her mattress was damaged and stated he would only replace it when he received his tax refund. In addition to that, the child is routinely exposed to marijuana use in the defendant's home where he smokes in her presence. The child often returns smelling like marijuana. The smell is in her hair, it's in her clothes, it's in her belongings. The defendant has other children as well. They are in contact with my client and often inform her as to what's going on in his house.
Well, but that's hearsay, though. So you don't-
Yes, Your Honor. Yes, but just stating it until the court is over, and we can have them testify later time until the court orders an evidentiary hearing. Your Honor, based on information, I believe the defendant has a drinking problem on January 10th of 2025. He asked his own 17-year-old son to drink alcohol with him. It's creating an unstable environment for the child, and it's an unsafe environment for the child. He has exhibited severe mental instability characterized by uncontrollable rage, anger, impulsive behavior. It's creating a constant state of instability in both his life and the life of the children. The order does state both parties have to complete a psychological examination, Your Honor, but that has not occurred yet. If the court does enter an order today, I would ask that the parties.
It was all parties for a psychological eval.
Yes, Your Honor, that's correct.
No one has completed it?
No, Your Honor, no, that's not good.
Even your own client?
Yes, Your Honor, they tried to find a provider that would cover them through their insurance, but it's only private, it's quite expensive, but they are willing to comply today and get a psychological evaluation as soon as possible. And Your Honor, the defendant has posted a Facebook video questioning the child about not having a bed and being exposed to marijuana. He posted this video on Facebook. He's touching the child in a very awkward manner, and then putting in the caption on Facebook that this is my client's fault that they're alienating the child. He's failed to comply with the court order parent time schedule. He often misses scheduled visits. He hasn't followed the court order's phases of parenting time and cannot have Madison overnight on Sundays due to his inability to take her to school on time. The defendant has frequently asked my clients for food, both Madison and the defendant's son, stated there's not enough food at the house. The defendant does not have safe or legal transportation at his house. At one point, he admitted to my clients that he fled the scene of a car accident. He has job instability. He's had approximately 10 to 12 jobs in the most recent years. And based on information I believe, Your Honor, we believe he was arrested for panhandling, friendly with Michigan. Your Honor, he consistently disparages my clients and uses vulgar language towards them. We have that attached as Exhibit F, and I have some additional supplemental exhibits of Mr. Walters communicating with my clients using some of the nastiest language we've ever seen in regards to parenting time and co-parenting this minor child. Your Honor, he's threatened that if you were ever to be in full custody of the child, her maternal family would never see her again. This is deeply concerning due to the history of the hostile rage, the verbal abuse, the unstable living environment, all of which demonstrate a lack of adequate care. Your Honor, he's engaged in inappropriate behavior. My understanding is that he asked the minor child, who's 9 years old, to bathe with him, raising serious concerns for her well-being. He's never participated in the child's education. He's never attended a parent-teacher conference. He doesn't communicate with her school or her teachers, really assist with her homework. Again, my clients have had this child Monday through Friday since this order's been entered and up until a few months ago. So they've been doing all of these duties for the child. He's isolated the child from a maternal family and social network by refusing to allow her to attend family functions, birthday parties, and other social events, Your Honor. We're asking the court today to requesting an in-camera interview of the minor child so the court has a better understanding of what's going on with Madison. Your Honor, we're asking for his parent time to be suspended and for it to be supervised. If the court does not go with this suspension at a third-party facility twice a month at his own expense, until he can demonstrate the following: proper bed and sleeping arrangements, stable and safe housing, sufficient and nutritious food in a drug-free and alcohol-free environment, along with safe transportation. We're also asking for a guardian ad litem to be appointed to represent Madison's best interests and provide an independent assessment of her needs. Again, Your Honor, we're requesting also an in-camera interview of the minor child. Your Honor, my client also bought the minor child a phone. She pays for the phone bill. It's prohibiting the minor child from texting my client or having any sort of communication with her. And once again, Your Honor, I must stress the fact that I believe the parties should go to this psychological evaluation, have it done, and submit that the findings to the court so the court can make a decision moving forward as to grandparenting time and Mr. Walter's parenting time. And that's all I have for the court today, Your Honor.
Okay, before I go to Mr. Walter, on page 4 of the order,
Yes.
it says, based on the parties' agreement, after permanent custody is granted to the defendant, Jeremy Walter, the court finds that the guardian shall enjoy the following grandparenting time with the minor child until further order of the court. And then obviously it spells out what the grandparenting time is. We're not even there yet.
Well, Your Honor, respectfully, I don't believe Mr. Walters is sufficient to have sole legal and sole fiscal custody. I mean, all of the things that are going on in this motion, along with my numerous exhibits, it doesn't show that he made major life decisions for the child or has the moral fitness to take care of his child. Your Honor, I don't think he'll ever perfect sole legal and sole fiscal custody. I think he'll leave it as it is, leaving my clients in a limbo. Again, my clients have been the primary caretakers, and they're just taking care of their child or their grandchild as best as they can, with really no legal backing behind it at this point, because as you're aware, phase 8 hasn't been completed yet, and their grandparents have very limited for the order, despite the being primary. So,
But you would agree, though, that the order does spell out phase 8, second paragraph, on or after June 30, 2023. We're almost talking 2 years.
yes, sir.
The party, either party, may file the court, may motion the court for the perfection of custody of the minor child, and in the event phase 8 is successfully completed, then and in such event, permanent custody shall be granted to father. So we're not even there yet.
I understand, Judge. I completely understand the court's point, but Your Honor, the plaintiff, Patricia Sherrick, I mean, she's never participated in the case. Mr. Walters, he has not actively done anything in regards to having legal custody, having fiscal custody. It's more of a weekend thing with the child, and that's it. And that's his role as it stands. My clients are really acting as the primary custodians here. Under the grandparenting time statute, I'm not sure if they'd be able to pursue sole legal and sole fiscal custody, perhaps with their guardianship. But Your Honor, with this order that we have here today, I mean, the court has to take action. It has to get involved. It has to intervene with what's going on with Madison, Your Honor. It's very urgent.
Okay, thank you. Mr. Walter, your response. Please stand when you address it.
Yes, sir. First, I want to say my mother and Terry could have called Child Protective Services anytime to have these allegations investigated on Mitch's advice when that Mitch here, worker here.
You mean Mr. Holden?
Yeah, Mr. Holden,
Oh.
sorry. On Mr. Holden's advice, because I immediately went to him when I got this in the mail. I thought we had a great relationship. This is my mother. And when he says that, this is my mother here. And when he says that I'm keeping my daughter from my maternal family, this is also my family. My mother doesn't want me involved in our family. I live with my son all the time. They told me that Mitch told me to get a hold of child. Yeah, Mr. Holden, I'm sorry.
I mean, I don't call you by your first name.
Okay.
I'm being respectful. That's what I'm asking for.
Mr. Holtwood, on his advice, I got a hold of Child Protective Services. I said, I have food, I have a bed for my daughter. I took pictures, I sent them to Mitch and as well as the circuit court through email. And
Court can't look at them though. Court cannot look at them. If one party sends.
I sent it to his attorney as well.
That's fine, I don't
Oh,
care,
okay.
but you have to understand the rules of evidence. Anyone can send the court whatever they wanted,
Okay,
but it has to be entered through the court as an exhibit.
okay,
So
well, I didn't
if you wish
understand
to
that.
offer that down the road, that's up to you.
Okay.
That's why.
Well, I do, mainly what I want to say in his allegations, I thought that we had a good agreement. I know right now my license is suspended. I have had some troubles, with work and stuff, and I thought that we had a good, my mom lives less than a block from my house. I thought that Madison, you know, on the weekends, I get my daughter, my son lives with me all the time, and I also get my ex's daughter, Remy, which she doesn't have a dad. And I've been having her, they've been raised as sisters. My mother doesn't want Remy and Madison to be sisters. I guess, because she doesn't want, she's done everything in her power to try to, like last year on Madison's birthday, my daughter Remy didn't even receive an invite, but my son Caden did.
Okay, Mr. Walter, the allegations are that there's questions regarding the child's mattress and sleeping in a wooden box.
Yeah, okay. When they took that picture, I'll tell you what happened with that.
Well,
When
okay, please.
It was a 60-degree weekend, the weekend before. I had Madison's bed out in the shed. I let my girls camp out there, okay? In the shed. Well, the next weekend I didn't bring it right back in. And my parent, or Terry and Brenda, I told Madison, take a picture that your bed's out in the shed right now and say you don't have a bed. And I literally, they called the police that night. I sent a video to Mr. Holdwick and the court as well. I mean, this was before we even had this court day. I sent this to Mr. Holdwick because he's been the one all along that's overseen my case. And any evidence we have of wrongdoing or anything, I've always contacted Mr. Holdwick. He's always been real and legit with me and always been very respectful. I mean, I like Mr. Holdwick a lot. Anyways, I sent that immediately to him. He said, should we file a motion? I said, well, I have used bad language over app close. I don't want them to file a motion too. I guess we can just let it go to let it go. And I won't go through with this because 2 weeks ago, your court actually had a date set up that we were both gonna have to go to court for our motions that said that, I use bad language on app close. I mean, I guess you would call that abuse of our order, or I don't know what the correct legal term is, but I was gonna have to come to court to say that my parents coached Madison to take a picture of that bed, and I sent that to Mitch, that was all set up, and then they were gonna come to court and said I used bad language over app close. I said, I thought we were getting along again. Like I said, my mother was in my home smiling, taking pictures with my daughters. I went to daddy-daughter dance. I thought things were fine, so I didn't want to push that matter. I have enough stuff going on in my life. I'm in college with a 3.9, 8 months away from getting my bachelor's degree in writing for film and television for LA Film School. I didn't have time to put myself into this legal craziness. And I thought that me and my mom could get along. I'll admit, I have not pushed the order. Mitch has told me for a year, Jeremy, you can perfect the order at any time. But I didn't feel I was quite capable to have Madison all the time. And I thought we had a good enough relationship that I could have my daughter on the weekends. My son lives with me all the time, like I said, and I thought that we could continue the way things were until I was, financially stable enough and to be able to give myself 100% to my daughter. So I was waiting and leaving things as they were. I mean, I'll admit to that 100%. But these crazy allegations are making of no food in my home. Anytime they could have called CPS for 2 years. And another thing too, I never asked my daughter.
You're not denying it. You just.
No, I am denying.
No, you didn't. Not initially. You said they could call CPS at any time.
No, I'm saying, yeah, that means I'm denying. I have food.
No, it doesn't mean you're denying it.
Okay, well, that's what I meant to say, sir. That's what I meant to say. Sorry.
How do you respond to the marijuana usage?
I do use marijuana, but never in front of my children. Never. Never in the same room as my child. Never.
What about the allegation?
I do not drink. I do not drink.
What about the allegation? Okay, you don't drink at all.
No.
And you've not completed a psychological evaluation either.
I believe I did because I did the counseling for an entire year leading up to me getting the order. And then also, my mom, a big part of our order in the phase A, I don't know if you looked at it, but it says that we're supposed to go into family counseling to repair our relationship, which my mom has refused for 2 years.
Your Honor, may I respond to that?
Yes, please.
Thank you, Judge. Your Honor, he sent an email to the court and CC'd my office. He showed a picture of a fridge that was full of food that looked like it was just stuck there last minute. However, if you look at the condition of the fridge, It is simply deplorable. I mean, stains everywhere, food drippings everywhere. I mean, it's just one of the worst things you ever saw when it came to showing that or trying to establish the burden of proof that he's able to provide for the child. It was just terrible. Your Honor, he never addressed having a bed for the minor child. I mean, I still to this day, I don't know if he bought a bed for the child. I don't believe he did. He never stated that he did. He never testified that he did. He doesn't have a good relationship with my client, never did. Because if you look at Exhibit F, he disparages my client using vulgar language. I brought additional exhibits as well, Your Honor.
Familiar the relationship
Yes,
with these individuals.
And Your Honor, in regards to coaching, there's no coaching going on. If we're asking for a guardian ad litem to represent the child, that's a third party independent.
Who's going to pay for that?
Your Honor, I would propose that the parties split the cost for that. And moving on, Your Honor, he admitted he is incapable of having the child full time. And we believe he has mental health issues, he's just not using his meds. Your Honor, I mean, all of that testimony taken into consideration, I think at the minimum, at least a guardian ad litem should be appointed in this matter.
What's your response to a guardian ad litem, sir? Please
First of all, I'm not really understanding what that is.
It's an attorney that represents the child alone.
I believe that I couldn't afford an attorney, obviously. It's crazy that my mom attacked me while I was out of work for a month and a half, and then my mom's like a spider lying in wait to come attack. I'm sorry, I know I shouldn't have said that.
Getting into the weeds, sir.
Okay, I'm just trying to understand, what does a guardian ad litem exactly do, though?
That is an attorney that represents the minor child and focuses on the child's best interest and needs. And they may make a recommendation to the court regarding how the child is to be living or where to be living moving forward. They can make recommendations.
I'm going to say that I don't agree with that. We have the motion in order for a reason. My mom has made it so I cannot complete this final phase of our thing. And I feel like she doesn't ever want me to have my daughter. I thought that we had a great relationship. I thought we were building rich. We spent Christmas together with our family, with my son. I thought we were building our relationship, and now come to find out that is not the case at all. So I'm going to say that I disagree with that. I think that I'm going to have to get an attorney, obviously, because of these allegations they're making and the things they're saying. But at this time, yes, I would deny that on my side.
What the court is going to do at this point, counsel, is we're going to, and you, if you wish to file supplemental pleadings, you may.
Yes, sir.
We don't have a perfect, you may be seated, sir. We don't have anything in the court order or anything that perfects the court order as it pertains to phase A. So as a result, we're still in whatever phase may be going on. If it's phase A, it's the previous phase. So I think the hearing is going to be about whether or not father's completed all the phases to perfect custody. In the event that he has, of course, we'll have the hearing on that. Then at that point in time, we can address grandparent rights.
Yes, sir.
If he is not, then we may have to look at potentially other phases or other remedies that may be available. I don't know. And also, too, let's be very honest here. Both parties reside in Genesee County.
Yes, sir. That was one of my next things to go to.
And unless the order is either perfected, because we can't hand off a case, a motion that's pending in this court to Genesee.
Right.
That's the court rule. We can't do that. So the intent of the court was, to be very honest, if there was a perfection and we get it perfected and you wanted to file a motion, maybe there's a stipulation or something that could be handed over to Genesee. That doesn't mean I don't want the case. That's not the point here. But you're coming in from where?
Well, where's
your office, sir?
Oakland County, Birmingham, Michigan.
Right. I'm thinking Saginaw Street, north end of Flint is a heck of a lot better than East Huron Avenue in Badass, right?
It was a nice drive up here.
Well, you'll say that. Hopefully you won't say that hopefully you'll say that during beat season, but that's another story. But sir, you're from Genesee County as well. And I'm assuming you'd rather have this matter heard in Genesee if we're able to do so.
Yes, sir.
And I'm not going to speak on behalf of your clients, but I'm thinking they're probably thinking the same.
Yes.
So, but we can't do that yet. So we are going to schedule this for a hearing to determine whether or not the order has been perfected, the motion regarding GAL, all the other motions are preserved, and Ms. Hatch will schedule a special day for that, and it's going to take some time. How soon would you be ready for a hearing?
Your Honor, possibly mid-May, early May.
May 13th.
Check the calendar.
Does that work for you, sir?
Yes, sir.
And then that'll give you time if you wish to seek counsel, if you wish to do so.
Yeah, and I'm back to work now also too, but I actually couldn't get my paycheck early. I was gonna try to make some child support because I haven't paid child support in a couple of weeks either. I need to get on that, so.
Okay.
Your Honor, was it May 13th for an evidentiary?
Yes, 9 a.m.
Yes.
9 a.m. Also, this is to Mr. Walter. Mr. Walter, the court does not appreciate when you call the county clerk's office and when you're trying to get either videos or pictures to the court, you basically tell them they don't know how to do their job. That's not appropriate. They know how to do their job. You don't know as it pertains to how matters come before the court, how evidence comes before the court. This individual does because he's a licensed attorney and you're not, and that's no disrespect. Hence, number one, it's probably a good idea for you to seek counsel. Number two, being a little more respectful will go a long way because the clerk's office is an extension of this court. And that's why you don't hear me calling you by your first name. You don't hear me saying anything disparaging because I'm being respectful. And I'd ask you to do the same. It has nothing to do with the merits of this case, but it has a lot to do with how you treat other people. We'll see you next.
Thank you, Judge. Have a wonderful day.
Thank you. That'll be all. We're going to give you notice right now. These parties are present on behalf of the plaintiff. His attorney, Julian M. Ferris. Mr. Titus appears in pro se. Will both parties please raise your right hands?
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
Thank you. Ms. Ferris, you may proceed.
Thank you, Your Honor. The parties had, this is plaintiff's motion. Julian Ferris on behalf of the plaintiff, Captain Titus. This is her motion for injunctive relief. And the parties did have an opportunity to speak this morning, and we have reached an agreement on these interim issues. The parties have agreed that Ms. Titus will have exclusive use and possession of the marital during the interim of this divorce proceeding, that she will be responsible for the bills, insurance, and taxes on that home while she occupies the home. That Mr. Titus will have 10 days from today's date to move from the marital home. The parties have further agreed that each of them will have exclusive use and possession of a vehicle. Ms. Titus will have exclusive use and possession of the 2014 Ford Edge, and she will be responsible for any payments and insurance on that vehicle during the pendency of this action. The defendant, Mr. Titus, will have exclusive use and possession of the 2007 Chevy Blazer, and he will be responsible for any payments, costs, and insurance on his vehicle during the interim of this action. The Blazer is currently broken down. Mr. Titus is responsible for setting the appointment to have the vehicle fixed. Ms. Titus will be paying for the cost to repair the Blazer. And the insurance, she has agreed to keep the insurance on the Blazer through April, but starting 1st of May, he is going to be responsible for the insurance on his vehicle. Then regarding the mutual restraining orders, we have agreed that both parties are going to be enjoined and restrained from damaging, hiding, transferring, selling, or otherwise encumbering any of the personal property of the parties during the pendency of this action. And then we're also asking and have agreed that both parties be enjoined and restrained from striking, beating, harassing, molesting, or in any way interfering with the life and well-being of the other party during the interim. And this applies not only to verbal comments, but also text messages and social media posts. And I believe that addresses all the issues to this point.
All right, would you please ask or inquire to the respective parties?
This one.
They have.
Okay. Did you hear what I just placed on the record? Is that your understanding of the agreement that's been reached today? Correct. And would you like the judge to order that that be done? Yes, please. Mr. Titus, did you hear the terms that I placed on the record?
Yes.
Is that your understanding of the agreement that's been reached for these interim issues?
Yes.
And would you like the judge to order the same?
Great. Thank you, Ms. Ferris. Thank you both for being able to agree while this matter is pending. And Ms. Ferris, how long will it take you to prepare the order?
Okay, 2 weeks, Your Honor?
Sure. We'll set a control date for April, aren't we?
Yes.
March.
So
April
April,
11th.
Oh, sure.
Control date for April 11th.
April 11th? Okay, thank you, Your Honor.
All right. You're all set then. Thank you.
Thank you.
Have a great week.
Thank you.
To DM Ashley Lynn Feretsky versus Jared Wesley Feretsky. This is the plaintiff's motion regarding legal custody and support. Plaintiff is present, defendant is present, pro se. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. Ms. Feretsky, what are you requesting and why are you requesting this, please?
So I'm here in regards to the motion that I filed for child support reevaluation and custody. I would like that addressed today, please.
Okay. Let's begin with child support. What are you requesting?
May I read what I wrote, just so I
Sure,
don't
this
forget?
is
what
your
I wrote?
opportunity to speak to the
Okay.
court.
We have been here several times since our divorce in 2017. Nothing has changed, not one thing. He will not communicate with me still. In fact, it's gotten worse. The defendant has not communicated with me since August of 2024. I have tried to communicate with him regarding the kids, anywhere from medical issues, school issues, and most importantly, general parenting issues. He doesn't seem to care about medical issues or school issues. He doesn't go to doctor's appointments or parent-teacher conferences at school. The last time we were here was because he would not agree to help pay for our daughter's orthodontics, and he did not show up for the ruling. Our son was struggling in school, and it was addressed in a doctor's appointment. I communicated this to the defendant and received no response. Our son was also not following school phone policy. I was not aware of this until I got a call from the principal that he received his third phone infraction, and it is going to be taken away for the remainder of the school year. I found out in that phone conversation that the defendant was called regarding the second phone infraction, and he had to go to the school to retrieve the phone. This information was not relayed to me by the defendant at all. In closing, okay, I got divorced 8 years ago on May 17th, 2017. I was approached in front of the court and your honor several times. I've emailed in front of the court several times. Unfortunately, all of the things he has been told to do haven't been done. Today, I'm asking for the court to make a decision regarding the motion. I have been complying with all the court's decisions, but the defendant doesn't seem to think that he must do the same because there are no consequences. Overall, I'm just drained. I have been trying to co-parent effectively to no avail, and it's just not fair to the kids. I want them to be kids. I don't want them to have to deal with adult issues or situations. That's why I'm asking for full custody and review of child support, including shared expenses of car insurance and extracurricular and or school-related activities. I am also asking that communication be addressed as well. I
All right.
appreciate your consideration. Thank you.
You're welcome. Can you explain why you're requesting a child support evaluation? I read the motion, but I just want to hear.
Yeah, he has a new job now.
Okay. When do you believe he obtained new employment?
Probably a year ago.
Year ago.
Maybe. I'm not really sure.
Anything else regarding either motion?
Just basically the communication. Our oldest son, he's going to be turning 16 next week. I do want to address insurance being split 50-50. If we can.
You put in your motion, I am open to no child support being paid if all extracurricular school-related expenses and any other agreed upon expenses are split equally.
Correct.
And you still stand by that?
Yes. As long as we do it 50-50.
Okay. All right, Mr. Bransky, your response.
Well, in the start of 2017, I had to pay child support of $240 a month because it was based off of my overtime. I asked the friend of the court, Ashley, and you, your honor, if we could go up to 40 hours, and all three was denied. In 2020, I lost my job at home school and started working at C-Star. In the June of 2020, Ashley ran a stop sign putting all 3 kids in 3 different hospitals, and she was in the 4th. I had to quit C-Star to take care of my kids because both boys couldn't walk. I had to take them to follow-up appointments at early medical and to view of them. I did not take her to court for any of that. In that summer, I bought my oldest.
Why would you take her to court for a terrible accident?
Because it's medical expense. I had to quit my job. I was still paying her $240 a month when I had no job. I didn't do an income review or nothing.
Okay, go ahead, sir.
So in 2020, I bought my son a truck because he turned 16. Because he didn't feel safe driving in anything else. So in 2021, I suggested to Ashley that she could pay for the plate for the truck because my oldest son was driving her around because she lost her license for a year, and her response was, "It's not my truck." And she helped very little with the insurance. So in 2022, we had court or extracurricular activities, and it was granted that I had to pay what she wanted, which was not in my divorce papers. Also in 2022, I did not have my kids on Father's Day weekend because she planned vacation time and friend of the court granted her the vacation. So I knew she made more money and I was tired of Ashley in favor. So I did an income review and she was suggested to pay $190 a month, but you lowered it to $50 and looked at her and said, "That's the best you can do." So with my son turning 16 next week, I have a 2011 F-150 sitting in my driveway that is not being drove. So I made him a deal that he could work and pay me a little bit of money and he could save the rest of his money the rest of the summer. So he thought about it for a while and he agreed that that's what we would do. But his mother said, no, he cannot drive that truck. So now he's going out this weekend and buying a car and putting her name. And the reason why Preston stayed at her house most of the summer is because he worked at Bird Creek Hockworth, which was literally 2 miles from her house. My parents live 1 mile from her. My grandma lives 2 miles from her. And my oldest son, which is 20, lived at her house. And he also works at the golf course. And he made quite a bit of money last year working. There's so many businesses out here that complain that kids don't want to work. And he worked his butt off all summer, and now she wants to use this against me. And she has dates written in there on how my daughter was at her house. The first date is in July 13th, correct?
Which day are you referring to again?
July 13th.
In the motion you're talking about?
Yes, it's in the paperwork.
July 13th, that's listed.
That is my daughter's birthday. And in the court papers, that is her weekend to have her. It was her time with the child's birthday. So she just uses these kids against me any way she can. So my daughter and I got into going to Owen Speedway. And 2 weeks before that, she wanted to go on her birthday because it was kids night. She asked me to take her. So I said, well, you're with your mother, so we had to talk to her. And Carly said, yeah, bro, that's not gonna happen. So it was like playing a guessing game with Ashley on what time I could pick Carly up to take her to the races. And it got to the point of, you just tell my daughter that I'm not taking her because you're being this way. It's just, I'm to the point, there is no co-parenting with her. So what's the point of talking to her? Just like this races issues. I told her numerous times I could not afford it. Why can't we wait 2 years to when I can financially afford this? But she refused to listen to me, brought me to court twice because it's in my divorce papers and you granted it. Now, and then you garnished my wages. I even talked to the lady that called me for a payment plan, and I asked her what would happen if we waited 2 years. Carly never even seen that dentist for her to tell me what happened if we waited 2 years or a year. She was never there. The day she showed up is the day they put the braces on. And she called me back after that first appointment and said there's nothing they could do because she had an order to put the braces on.
court didn't order the braces to be put on. The court ordered that you were to pay half the expense.
Well, it was granted.
The order to pay half the expense was granted.
Yes.
The court didn't say, go get the braces.
Okay, my apology, I worded that.
Well, I want to make that clear. I mean, the court doesn't go that far.
I don't understand why at 12 years old, she could not wait a year or two to get braces. Her teeth did not affect her every day-to-day life. I understand they're crooked. I have crooked teeth also. She never once complained about her teeth hurting her.
Okay. How do you respond to the lack of communication since Mr. Retzky alleges that since August of 2024, that was the last communication you had with her?
What's the point of talking to her? She just comes here and get whatever she wants.
That's not always true, sir.
Yes, it is. Every case. There's cases that I tried to talk to you, you cut me off. Just like the instance the first time she brought me here. I tried to tell you I couldn't afford it, and you cut me off and told me to figure it out.
Well, when it comes to prior orders, if there's an order that's agreed to, the court doesn't look at whether you have money or not. If there's an order entered, the parties agree to it, the court enforces the order. That's all the court does. It's not a matter of, well, I agreed to this in 2017.
I never disagreed not to pay it.
Okay, you interrupted the court, sir. But, for instance, in 2017, the order says the parties shall be equally responsible for all school-related expenses, including extracurricular activities and sports-related expenses.
That is not 2017, that's 16. That's again, you're not going off my divorce papers.
I'm reading off the judgment, but regardless, at the end of the day, there's nothing here that says, for instance, based upon income of parties. It doesn't say that. Now, when it comes to the 17 order, May 17, you have joint legal custody, correct?
Correct.
And with joint legal custody, that means you agree to make decisions together in the best interest of your children.
I never once said I would not pay for braces.
Okay.
And I was not disagreeing that she did not need them.
Okay, but if you both disagree, if you disagree with something like that, you can bring it to the court's attention and the court can decide.
I tried to. You cut me off.
You're cutting me off, sir. I'm being respectful. I'm not saying you're being disrespectful. I can see the frustration. But if you're not communicating with each other, what's the court to do? If it's an issue regarding the discipline at school for an alleged phone incident or anything like that, if you're not communicating with each other, how is that working out for your children?
She was notified the first time. I wasn't notified. You understand? Do you see how this works? She just sits there and
Oh,
points.
I see how this works. I see how this works. I do. Did you get a new job, sir?
Yes, I did.
Congratulations. When did you start?
I don't recall the actual date, but it was,
6 months ago?
oh, it's getting close to a year.
Okay. Have you notified the front of the court of that job?
I know I did not notify them, but they know. I mean, you're garnishing my wages for braces,
Right.
so how do they not know?
Well, I don't see the front of the court file. I'm not allowed to see the front of the court file. But any change of address or appointment must be reported to the front of the court. But clearly, they obviously know. All right, this is what the court's going to do. Regarding the child support evaluation, there is a change in circumstance. Father has changed employment. So the court will order a front of the court investigation relative to support only. As legal custody in this matter, father acknowledges that in August 2024, he stopped communicating with mother. And there's an issue regarding medical decisions, school decisions, general parenting issues. Court finds that there's a change in circumstance regarding that as well. Parties share joint legal custody. With father's lack of responding, because he admits it since August of 2024, and I can understand the frustration though. There's no communication. If there's a medical issue that arises at last second and mom reaches out to dad, God forbid the child gets injured. And mom reaches out to dad and says, hey, look, we've got to get treatment for the child, and if dad's not responding, they technically can't provide medical treatment to the child because you have to have authority to do so. This has been ongoing for a long time, since the judgment of divorce has been entered. Court finds based upon that there's clearly a change in circumstance since the entry of the last custody order. The conditions surrounding custody of the child, which have or could have a significant effect on the child's well-being, have materially changed. Father again has not had communication since August of 2024. The request is regarding legal custody. There is no, as far as the court's concerned, there's an established custodial environment with both parents. Regardless of that, there is no change in request for custodial time. As a result, the court is going to apply the preponderance of the evidence standard. And though the court doesn't have all the factors involved, I mean, I don't question both parents loving and caring for their children and the capacity to provide that. But when it comes to the communication aspect of this, which is a serious component relative to that, there's been a complete breakdown, and the communication aspect clearly favors mother. The parties have the capacity and disposition to provide the children with love, affection, and guidance, as well as food, clothing, or other medical care. No issues that the court is aware of relative to the care in each respective home. But the significant factor for the court to consider is the inability of the parties to communicate when it is offered. As a result, the court is going to order in this case, besides the front of the court investigation relative to parenting time, I am awarding sole legal custody to the mother of the remaining children.
So I'm losing my kids over this.
No, you're not losing your kids. You still have the physical aspect of parenting time, but when it comes to the decision-making regarding medical, education, religion, because you're not communicating with mother.
She does not communicate with me all the time either.
Sir, I've made my decision. I've asked for you.
See, here we go, favoring her again. All because her mother worked for you. There's so much conflict of interest. It's ridiculous.
Far from it, sir.
No, it's not.
Well, you can allege it. The court's made its fine. That'll be all.
So what I gotta do? Get a lawyer to change this courthouse?
You can file any motion you think is appropriate, sir. Off the record, feel free to come back. Show cause hearing for Mr. Hockworth's alleged failure to appear. I believe that was ordered on March 10. For Holden or Schultz? Schultz.
We were last for court. Mr. Hockworth did not appear for the scheduled motion hearing, and so the court had asked for a show cause to have him before the court today. At the time of the initial hearing, with the order that entered on March 10th, 2025, the court had ordered with regard to the minor child E that she shall attend school every day that school is in session unless excused due to illness, as evidenced by a doctor's note. And on an interim basis, neither party was to leave the minor child alone without a responsible adult being present. The matter was otherwise preserved.
Both parties, please raise your hands.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. I'll begin with Mr. Hockworth. Sir, please state your name for the record.
Tony Hockworth.
Mr. Hockworth, there was a previous hearing scheduled in this matter, and it was scheduled for March 7th. Did you appear?
No, sir.
Why not, sir?
I forgot to vote.
Okay. And as a result, we didn't have the hearing, but the court did hear some information from mother. And as a result, on that day, the court entered an interim order regarding, and it's what Ms. Schultz stated, that the minor child may attend, as the child attends school. If the child is missing from school, there has to be a doctor's slip. And the court also ordered that neither party can leave the child alone without a responsible adult present.
I didn't get that.
Pardon me?
I got the letter.
The order?
Mhm.
Okay. So other than forgetting to appear, it's alleged that you left the child alone.
Not after I got that letter. She's been staying with grandparents.
But regardless of when you received, oh, okay, so you're saying that after
Yes, because I was told by CPS that they questioned her and they see no reason why she couldn't be there home alone.
Well, that's not the court order. We consider the court orders only.
And I got the letter and that's when I got a hold of my parents. And she's been staying there on my route now.
Your response.
On the 17th of this month started his week. And I had gone to his house to check on her, like I have been previously since he's been on second shift, because she has been alone and he knew that I was going to check on her. And at 7 o'clock at night, she was there by herself. So I took her with me back to my house. Well, actually, I apologize. I took her with me to get her lunch for her field trip the next day. And then I took her back to my home and made dinner. To which then he at 8:42 had messaged saying that he was home. So I brought her back. The next day we had her field trip and we didn't get home from her field trip until 4:45. Nobody was at the house. So I kept her with me. She thought that he was going to be staying after. I apologize. So I had messaged him at 6:48, telling him that if he was going to be working late, that she could just stay the night so that she didn't have to be woken up to be brought back for school the next morning. To which he replied that he wasn't working over. And so I took her back to his house at 10:15 and I stayed until he got home so that she was not alone. And then on the 19th, I had then went to check on her again and she was alone. So I took her back.
Sunday at this time?
Yes. So I took her back to my house. We make dinner. And again, before he returned home from work, we went back to his house and I remained in my vehicle again until he returned home. Once he returned home, I left because he was there and she was no longer alone. And then starting that next Thursday, following that day is when he left her with his parents. So Thursday and Friday. And if he worked the weekend, she was with his parents as well that weekend.
So you're alleging the last day the child was left alone was March 19th?
Yes.
Okay. The order that was entered in this case dated March 10. When do you recall you receiving it? Did you receive it the very same day? Or was it sent to you in the mail?
It was mailed the 11th and I received it on the 13th.
On the 13th. How do you respond to that, sir?
I mean, I don't have a problem with her going there and picking Emily up on my week. She's got dinner there every day. There's food in the house. And I see no reason why she can't be there while I'm at work. I mean, I am working, supporting the house. There's no issues. And Emily told me her mom fears that someone's gonna just walk in the house and kidnap her. That's not gonna happen. There's never been no problem since I've been on second shift.
When did you begin second shift, sir?
I've been close to December, and it wasn't by choice.
Oh, I understand. What's the current status regarding legal physical starting point?
An order entered on January 24th of 2019 granting joint legal and joint physical custody. And then the most recent order regarding custodial time entered on July 13th of 2022. And the parties are granted equal custodial time on a week-to-week basis. Exchanges occur on Mondays during the school year, and they're also granted alternate holidays for the work.
Okay, thank you. All right. Well, we'll address first the motion to show cause for failing to appear in this matter. I'll accept father's comments that he forgot about it. Unfortunately, mother was here, and obviously it's a waste of her time. And as a result, the court's going to order a $100 fine. That'll have to be paid by. Can you get it in by April 11th?
I think it's today.
Today? Okay. Payable to the friend of the court. We address that matter. Now we are talking about allegations of a violation of the order that Mr. Hockworth wasn't here on. But let's begin with the motion regarding custody and/or parenting time. Ms. Gage, what is the proper cause for change in circumstance you believe that the court should be looking at relative to changing custody or parenting?
Prior to the order, he had been being pulled from school to babysit or not sent to school in order to babysit. She had also been allowed to just skip school. She is, prior to this last order, she was being left alone all night until he would return home from work, usually about 11:15, unless he worked over. I was told specifically that I'm not allowed to lock the door when I leave, when I would leave her, after I would ensure that she was safe. I was specifically told I'm not allowed to lock his door, because if she's not up, he can't get in. So I fear for her safety because she's a minor child who has no phone. She previously had a phone, but was not responsible enough with it, so is no longer allowed to have it.
She's 11, correct?
Yes.
Go ahead.
What Mr. Hockworth does in his personal life is for him. But my concern is also the amount of women, the number of women that are continuously in and out of the house. At some point, or at one point last year, at the end of last year, there was up to 3 women staying nights. And then it was like a revolving door. And the effect that that is having on her worries me, plus the safety issue of that. I apologize. I have, Mr. Hawkins does have food in his home. He will not cook on his stove. So unless there is something that she can microwave, she will not eat. So that was my concern there. And I have taken food to his house so that she had something to eat, as well as when our daughter had previously been living there before she moved again. I have even gone to food pantries just to make sure that there was, because I don't have way extra to supply 2 houses. So I would sometimes go to the food pantry and drop stuff off to him. I am worried that her schooling was being affected because of being pulled out of school.
What are you alleging the amount of days a child may have missed?
She did not go November 27th. December 2nd, she did not go. January 9th, she was not in school. On the 8th, she was pulled from school early.
January 8th?
Yes, I apologize.
It's okay.
On January 24th, she was kept home from school as punishment because the prior night, when he returned from work, she was not home. He had messaged me asking if I had her. I said no. We got in contact with her friend who I had seen previously in the day with. We contacted her father to see if he had the girls there. He did not. I had asked Mr. Hawkins to go look for her, go to the park or school to look for her. He said he would not go look for her. So me and my husband had gotten ready to go to town to go look when he had said that she had shown up. On January 27th, she did not go to school because Mr. Hawkins had been gone all weekend. And he was left with one of his ex-girlfriends. That ex-girlfriend had gone to work that Monday and left her children with E. So she was there watching those children. And I believe that was all of them.
And that's the primary reason for your motion to change custody, correct?
Yes.
And are you talking physical custody?
And legal. But mainly physical, because I worry about her safety when she is there.
Okay.
Because she is alone, or had prior to the last order been alone all the time.
All right. Scott, what's your response, please?
I've never punished her and kept her home from school for grounding. Schools have sent her home growing up And I think the prior times of her missing school, I might have still been on first. Because there were days that she just wouldn't go to school. She'd play out sick or I was too tired. But since I've been on second shift, I'm up in the morning getting her up ready for school.
What about November 27th, December 2nd, January 9th, January 27th?
I could have still went on first. I would have to go back to see when I was switched on second. I've only been on second for, I think, 2.5 months.
Okay. But those were during your time, so correct?
Could have been.
You had a child. Mom, is that your allegation?
Yes.
Okay.
When I do make her go to school, when she said she was actually sent home last week on my week because she was thrown up at school. I still made her
Did you get a
go.
doctor's notice?
They sent her home. So I didn't even take her to the doctors for it.
Okay. All right. Court finds that there is a change in circumstance since the entry of the last order. The parties have joint legal, joint physical custody. The court had heard a motion, barely, father was not here, regarding the absences from school, and that's the reason for the change in circumstance. As a result, the court is going to order a friend of the court investigation relative to custody and parenting time. In the interim, though, the court is going to keep the prior orders in effect. We're still week on, week off. However, the prior orders that the court entered on March 10 absolutely apply in this matter, which means that in the interim, the child is to attend school every day that school is in session unless excused due to illness as evidenced by a doctor's note. We have to have a doctor's note. Either parent, if it's your time, child's not in school, we need a doctor's slip. If not, the child needs to be in school. And on an interim basis, the court is continuing the previous order that neither party shall leave the minor child alone without a responsible adult being present. According to Mr. Hockworth, since he was made aware of the order, the child's been with, sounds like his parents on those times. So that is going to continue. Relative to the allegations that father left the child alone after the court order, clearly the court order was entered. And it appeared the child was left alone. Father was here for the hearing. The notice of the order being sent, I should say service, indicates that that was mailed out March 11, 2025. At this point in time, it's not to happen again while this matter is pending. Neither party can leave that child alone without a responsible adult there, period. So I'll pass on the alleged violation clearly, but it can't happen again while this matter is pending. Do you understand that, sir?
Sure.
Okay. Do you understand?
Yes.
Ms. Schultz.
As to the friend of the court investigation, is the court ordering both legal and physical?
At this point, according to the motion, it's physical, not legal. So we're staying with physical. All right. Go ahead.
May I make one request?
What's that?
That as long as she is left with a responsible person who is not on the sex offender registry or has had any charges of child endangerment or anything.
Abuse or neglect?
Yes.
Any objection to that, sir?
No, sir.
Okay.
Only makes sense. Yeah. What? That'll be in the interim order as well. Do you have any questions?
I got one thing to say. So,
Is that a question?
well, the one thing I got upset about her locking my doors is there was no communication. So when I come home at 11 o'clock, I'd be locked out of my house. I'd have to bang on my daughter's window, wake her up, just so I could get in my house.
You don't have a key? Get in?
I got a key, but when she's home, you know, I leave my keys for her in case she wants to go uptown. If she locks the door, if the door gets locked, keys are there. But
Keys
no.
aren't very expensive.
Yeah, I know, sir, but
I mean,
I'm just saying,
it's not
like,
that difficult to go to one of the local
there's-
stores here and just get an extra key made.
Oh.
I mean, it's just common sense.
but communication goes a long way too. And
Well,
she could've
and that
said-
leads me to another point, because I was reading the messages going back and forth. It doesn't look like that's accurate. It looks like text messages, unless.
No, we haven't gone through Apple's in probably quite a few years.
I
Alright.
believe Apple's was previously ordered, Your Honor, but either party has brought it to the front of the court as an issue.
Okay.
No, we've gotten along for quite a few years. She's just upset that I'm on second shift and Emily's home alone. but I've never left her overnight. I lied to my ex just so I could keep my little ones longer, saying that I was,
Well, be careful what you say in the courtroom, sir.
well,
I mean, the exes could be listening. All I can tell you, if you're being able to communicate, I'm not going to change it. Just communicate with each other. That's all. If there are any issues, share them with each other. And if we have to go back that close, we will. But it sounds like you're communicating. This is the plaintiff's motion to abatement of child support. Both parties appear. Ms. Anchor is in the courtroom. Mr. McClan appears by the Zoom application. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? Yes.
All right. Thank you. Ms. Anchor, what is your objection?
From my understanding is, yes, he broke his arms in January, but he was also getting FMLA, which he stated on the parenting app, and he stated here in court on February 14th when he came in on another court date, and he stated that he would also be going back to court in March, or back to work in March, sorry, and that he was getting FMLA.
Sir, are you back to work?
No,
And are you currently under FMLA?
no.
Family medical leave?
FMLA does not pay anything also.
What's that?
I said FMLA does not pay anything. FMLA is just family medical leave of absence. And that was just supposed to keep my job until we got further through the process with my surgeon. I've had 4 surgeries. My last surgery was February 4th, and that was shoulder reconstruction. My last appointment was this week, Monday, and you guys have all the paperwork from my doctor. I'm not going to be going back to work until at least, and this is best case scenario, reevaluation will be in August. But I had been advised by Dr. Travis that the likelihood of me being able to go back to work is very low. I am in physical therapy. You guys also have my physical therapy schedule. And been in talks with Levine Benjamin, attorney, to try to get on Social Security and Social Security disability. I've also gotten a hold of DHS. I've gotten food stamps approved. I'm trying to get Medicaid to go in here. My next appointment with Dr. Travis will not be until 3 months from this week.
Are you receiving any income at this point?
I have nothing. I tried unemployment, but due to my injuries, to be eligible for unemployment, I have to be capable of working and eligible to work full time, which I'm neither.
How are you supporting yourself currently?
I'm not. I'm behind in everything.
All right. Can I hear from the front of the court?
Mr. McClan had originally provided the friend of the court office notice of his injuries in January. At that time, he did not meet the criteria for incapacitation, which is that a payer will or could have a condition that will last 180 days or longer. He subsequently provided additional documentation to our office, and he appeared to meet the criteria for incapacitation under the support formula. We issued the notice accordingly. He has provided our office with his updated medical records, information regarding the status of his claim with unemployment, as well as proof of an application for disability benefits pending with Social Security Administration.
And regarding any records that the front of the court may have received relative to medical records or anything like that, that's not the same as the court file.
That is not the same of the court file, nor is it subject to disclosure under HIPAA.
Okay. So I don't have that. I have to rely upon the front of the court. Ms. Ms. Anchor, do you have anything else to substantiate your claim here regarding the abatement?
No, I'm just going by what I was told because, since court, since January 23rd, he has not reached out. He doesn't see his son. And he's in and out of our son's life, so I'd actually like to request that I have full legal custody.
Well, you can file a motion with that.
Okay, because he's in and out, like he has no, this isn't the first time. He's literally in and out of his life so much.
Okay, well,
And he hasn't seen him since Christmas and hasn't talked to him, hasn't reached out to
well,
me.
Ms. Ader, we have to focus on the abatement request. That's why we're here. That's the only reason, why we're here. And I don't want to get into the weeds. That could be another motion if you wish to file it. But according to the information provided by the court, to the court, considering the testimony, and again, I don't get any of the medical records, none of that information. Front of the court processes that, and I don't even get to see it. But the court finds that the abatement is appropriate. There's no income received. FMLA is merely a program that allows you to essentially keep your job without having to lose it while you're on medical leave. And I'm not aware of any situations, unless there's some sort of other agreement allowing someone to receive some sort of income while on FMLA. So as a result, the objection is respectfully denied. But if you wish to file other motions regarding other matters, the court will hear those.
Okay.
Good luck to you. Thank you both. That is all.
Thank you.
This is the plaintiff's motion to transfer case. The parties appear by the Zoom application. Would you both please raise your right hands?
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
I do.
Yes.
Thank you. All right. We had a conversation off the record, Ms. Bosik, with Mr. Davis.
Okay.
And I had asked, one, whether you were appearing, and number two, and not necessarily in that order, what his position was on it. And it sounded, according to what I understood, and Mr. Davis, you can correct me if I'm wrong, you agree with this. Is that correct, sir?
Yes, sir.
Okay. So the petition is to transfer this matter to St. Clair County. Is that correct, Ms. Bosik?
Yeah.
Okay. All right. Where do you, I don't want to know the specific address, but what county do you currently reside in?
St. Clair County.
How long have you been there?
I believe for about 5 years now.
Okay. As far as you know, is Mr. Davis a resident of Huron County?
No, he is not. Not that I'm aware of.
Okay. What county is he a resident of?
The last I knew, I believe, was Wayne.
Okay. And why are you requesting the transfer?
Because I don't live in Huron County anymore.
Okay, is it more convenient to address matters or to deal with custody, parenting time, support issues in Huron County, or is it easier in the county that you reside in?
I believe if we had to, it would be easier to do it in the county that I'm currently living in rather than Huron County, because it's a trip for both parties to travel to Huron County.
So not only is it the residents, but the convenience to the parties. Is that correct?
Correct.
Okay. And do you know what contiguous means?
To continue something?
Well, let me ask you this. I'll make it simpler. Is Huron County's border, does it touch St. Clair County?
No, I don't believe so. It's Tuscola. Or is it Tuscola or Sanilac? Right. Right.
Okay.
Tuscola, Sanilac. I know. Yeah, there's a county separating me and Huron.
Okay.
I do know that.
So you would agree then that St. Clair County is not contiguous with Huron County?
Correct.
Okay. As I hone in on the answer there. Mr. Davis, you've not been a resident of Huron County recently, have you?
No.
Not even for 6 months previous?
No.
Okay. You currently reside in Wayne County?
Yes, sir.
Would it be easier if you had to deal with motions or friend of the court issues to drive from Wayne County to St. Clair, or would you like to travel from Wayne County to Huron?
Wayne County, St. Clair.
Would it be easier?
Yes.
At least transportation wise, correct?
Yes.
Okay. And you do not object to this request, correct?
No, sir.
Okay, great. Is there an SCAO?
Yeah, there will be.
There will be. Okay.
If the court would be so kind as to address the issue of filing fees for St. Clair County. I see Ms. Bosik filed a fee waiver, which was granted here, but it is her motion, so the court does need to address the filing fee for St. Clair.
In what way? I guess I'm confused.
It's a new case in St. Clair, the $255.
Shouldn't
Unless it's waived.
Are you able to pay the $255 filing fee in St. Clair County, Ms. Bosik?
Not currently, no.
Okay. And would you agree that that is a hardship for you?
Most definitely, yes.
As a matter of fact, you filed a fee waiver request in this file, correct?
I believe so, yes.
We'll waive this file as well. Court finds that under MCR 3.212B, all conditions have been met. As a result, this file, as well as the front of the court file, and all enforcement measures moving from this day forward, once the order is signed, will be transferred to St. Clair County.
Okay.
Anything else?
You're also ordering that the Huron County friend of the court continue to enforce the existing support order until such time as St. Clair confirms their release.
That is correct.
Thank you.
Yeah, the enforcement mechanism will stay here until St. Clair County receives it and they accept it.
Okay.
Any questions?
No, sir.
Sir, anything?
No, sir.
Good luck to both of you. Wish you both the best.
All right. All right. Thank you.
This is a motion regarding parenting time and show cause regarding alleged violations of parenting time orders. The plaintiff appears in the courtroom, Ms. Kruger. Mr. Spencer appears via the Zoom application. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. Anything from the front of the court first on this?
Your Honor, in addition to Mr. Spencer's motion, the front of the court had also filed a notice of hearing regarding an alleged violation of the order from January 2nd, 2025. Specifically, the provision that states there shall be no parenting time at a camper trailer until there was a motion to the court with witness testimony to have that modified, as well as in that same order that if there is an alleged violation, that there'd be an ex parte order suspending Mr. Spencer's parenting time. I do believe that there was a hearing previously, one second, on January 24th, based on the allegations or a complaint that order was being violated, and that was filed by Ms. Kruger. And at that hearing, the court found insufficient evidence to demonstrate a clear violation, and it was dismissed. The front of the court office had received complaints from Ms. Kruger stating that this has been a violated order, that parenting time has been happening at that residence. She did email our office with the complaint stating that there was an incident report with the Michigan State Police. On March 5th, we received another complaint that it was continuously being violated, as well as receiving a copy of said police report from the Michigan State Police, which was attached to the notice of hearing. That does state that there was parenting time at the home, but also that home was allegedly adequate. So based off of that report, Your Honor, the front of the court had set this for a notice of hearing for the alleged violation to hear from the parties given the information that was provided.
Okay, great, thank you. All right, let's begin with the show cause first. Ms. Kruger, why do you believe that Mr. Spencer violated this order? What evidence do you have?
He verbally admitted to me that he was there, for one. Two, I called the police to document it, so I have the documentation. And I mean, I didn't report the last one, but I mean, I dropped them off. I know that I see it with my eyes, and I made sure I called the police now because he calls me to tell me, like, I'm taking him here. The state police said, if you read the report, his account of it, we had.
Do you have the trooper here?
No, because when I called, it's not my motion. I can't subpoena anybody, I was told.
Who told you that?
The friend of the court secretary. I don't know her name, but this is Anthony Spencer's motion. I can't have it adjourned. I can't wait to have it heard. You guys can't give legal advice. There's nothing I can do. I come into court today, I was told, and I can address it with you today. I believe it's maybe Mary that I talked to. If there's it wasn't Ms. Schultz, it wasn't Mr. Holdwick, it was one of the secretaries.
There was information presented to me by friends of the court staff, but that was limited to whether or not the matter could be adjourned. And the instruction that I had given to staff was that it was Mr. Spencer's motion, either he had to agree or that request had to be made to the court today.
Does that sound about right?
Yes.
Okay, and then that is the protocol.
Yes.
Whatever is the other party's motion, the court, if the other party says, hey, I need this adjourned, the court can't adjourn it unless the other party agrees.
No,
or we have a hearing.
Honestly, I didn't know it was being added, so I can't really subpoena somebody in 4 days, 5 days. You know, it was added on to his motion
Okay.
a week prior.
So what are you requesting regarding this hearing today?
I would like to subpoena the police officer so he can, I know that he put in the report, but there's a lot in that report that is not, it's, if you ask me perjury, he lied to a police officer. He said we had court. You were going to allow my child to go the following week back to his house for visits. That's not true. That is a lie. And no circumstances have changed to allow him to go there, to allow any of it.
Okay. Mr. Spencer, what is your position, sir?
On the motion or the
Request to adjourn.
request to adjourn it this year?
Yeah.
I would like to continue on with it. It's been 5 months already. It's been since November since this has been going on. And this has been affecting my overall work and my health and finances, and also with it just makes it hard for Tanner and I also, and his friend that came up to visit at the same time.
Okay. Do you want to respond to the allegation that the child had parenting time at the place the court prohibited?
Yeah, I will explain that. There was Tanner's friend Michael came up for the weekend with him for his visitation, and while he was up here, we went to the original location of Scott's. Well, Tanner has a 4-wheeler, and there was snow on the ground. He wanted to ride his 4-wheeler and pull the sled around with his buddy. I also had to work that day, so I stopped at the house, which I'm only 3 houses away from where I work, and grabbed the 4-wheeler and the sled, and I had to load up all 3 dogs and my son and his friend. And as we're getting the 4-wheeler ready at the end of the driveway, my dog got hit. I had to call Sheriff's Department. Sheriff's Department had to call Animal Control. Animal Control had to call me back. I couldn't take my dog into the emergency or whatever. I called Mrs. Kruger to let her know what happened. And I says, all right, we were at Scott's. All the stuff's over there. We came over here to play with the kids. And while we were trying to tie the sled up to the back of Tanner's 4-wheeler so they could ride around with it and I could work and they could be in the yard playing, my dog got hit. So what do you want me to do? Would you like to pick up Tanner and his friend? I already called Tanner's friend's parents and they had no problem with him coming to my place in the first place. They said he can just stay. That's no issue. Nicole says, well, I don't care. It's not part of the order. And I said, well,
What do you mean she doesn't care?
She
doesn't
don't
care about what?
My dog getting hit and the fact that I couldn't leave or do anything, but I offered her if she wanted to pick up Tanner because of the court order that she could. Instead, she said she don't care, whatever, hung up on me. And we stayed. And like I said, the parents of the other kid were fine with it. Everybody's fine with it. The next morning.
So you acknowledge violating the court order then?
I had no choice. I was an emergency situation. I absolutely do. Just like last time when she did the court and I had a court order and then she brought a motion in whatever. I'm not here to lie or deceit nobody or whatever. I'm just here trying to be a father for my kid. And there's nothing wrong with my place. It's just that we were still staying at the other place, but my dog got hit. There was an emergency. I asked her to come pick Tanner up so there wouldn't be an issue with it. She refused. Instead, she called the state police and the state police showed up the next day instead of right then and there, because I had the sheriff's department over there.
So you had an overnight then, so you had an overnight with the child at your home?
Yes, I did. Not intentionally. It was just because my dog couldn't, it was like minus 10 degrees out with what do you call it? And I have 3 dogs. I couldn't even pick her up. She had a fractured rib and she had surgery in that leg with a titanium pin and screw. And there's no emergency vets or no place to take my dog. And I couldn't, I was just
Excuse me just a second. I apologize for interrupting, but why couldn't you have taken the injured dog to another location so to comply with the court order?
Because the location that we just came from, which was at Scott's, is over like an hour away. And to put my dog in it, I got a truck with 2 kids in it with all their clothes and all their stuff. It's minus 10 degrees outside. There's like a foot of snow on the ground, 1.5 feet of snow on the ground. And I have 2 other big dogs. There's no way I could make sure that she was safe in a safe position or place to travel with the dog or move with the dog. That's why I had to call her immediately to let her know. And she came and picked up Tanner and his friend later on.
Any other comment regarding the alleged violations?
I would just like to clarify, I was 10 o'clock in the morning, they were at the camper this morning, that just happened. He was on the toilet going poop when I called him. He'd just woken up. They never went to Scott's. And he never offered for me to come get my child. I have to call the cops and notify the other child's parents that he was there, because if my son's not allowed there, his son shouldn't be allowed there, I wasn't aware.
That doesn't apply. It only applies to the child in question.
The situation is that I was not informed I could come get him, or I would have. I allowed parenting time to happen because I don't want to be held in contempt. I would like to follow your rules and just keep doing this to just prove it can't be followed on that behalf. That's it.
Okay. Any other comment regarding that issue, sir? Mr. Spencer.
Just that she's lying and that she was called and told that she can come get him. So there was no violation of him staying the night at the residence. Like I said, I work right here. This is my neighborhood. I'm actually at one of my places now. Just I have to eat and stuff like that, and I wasn't intentionally violating his thing. It's like he's 10 years old. His buddy's 10 years old. They have nothing to do at Scott's. These visits been going on there for the past 4 or 5 months since November, and this is all put in the motion regarding in my motion that I have for today, that I filed for today, but we haven't discussed that part yet. So
right, we haven't. And you're requesting the adjournment relative to the alleged violation, correct?
Unless he confesses to it.
He already did.
Forward,
he already did.
If he's going to confess and take ownership, then I don't need the police officer to testify.
Okay. All right. All right. Well, based upon the testimony, the court finds that there is a violation because of the fact that the child is not to be there for parenting time. It was clear in the order. The the defendant alleges an emergency regarding a family pet that needed to be taken care of. And frankly speaking, no disrespect, but it could be, whether it's an hour drive to somewhere else where the parenting time is normally held, that should have been done, but it wasn't done. This allegation regarding, well, she could have picked the child up, doesn't fly with the court either way, because it's father's time. And and then father made the comment regarding the amount of snow involved. And if I'm not mistaken, Gaylord's had a high amount of snow this year, record amount of snow.
Record amount.
Yep. And so based upon that, I don't find that reasonable. $100 fine will be imposed. It is due April 11, 2025, payable to the friend of the court. Let's hear your parenting time motion, sir. Go ahead.
Okay, Mrs. Kruger has denied visits, seems to do this every year, Thanksgiving, Christmas, New Year's, Easter, during the holidays. I've had multiple checks and safety needs being met, and I've also been okayed and approved with all needs being met. I have fire extinguishers, smoke, and carbon monoxide detectors. All heat sources used in-house are certified indoor safe through the federal government. I do the store heaters inside for work and other things that I've done, heating, cooling, for the past 10 years. 7 years at CHS out of Ubly, Michigan and Pacific. Leonard Bradley and Nicole Kruger were both behind using the court and other public offices as a tool to threaten, jeopardize, and try to withhold my visits as a vengeful tactic to get at me and in turn hurt our son in the process. This manipulation of the court should be looked at and looked into, and this seems to also happen everywhere I have lived in the past 10 years. I've lived in Bad X, Newberry, Harbor Beach, etc. Ms. Kruger is now calling zoning anonymously, and zoning's given me anonymous white woman that called on the situation. She's called my HOA president. December 6th, calling sheriff to do a wellness check on me for not answering her calls privately through her mother's, Charlene Kruger's phone, instead of using the app close as ordered. Lenny Bradley also has sent text through Andrea Camacho to start this, as well as stating in text immediately after court on Friday the 6th that I should have listened, and it doesn't pay to F with me, you a-hole. This was immediately after the last court date where you suspended my visitation rights based off of Nicole stating that my place wasn't safe. And then this has been the past 5 months that this has continued based on her word that it's not safe. All messages have been forwarded through email to Mitch, including MDHHS, okay for Tanner to continue visits. Ms. Kruger, also on the visit with Michael, Tanner's friend, told Tanner and Michael were talking, and Tanner told Michael in front of me directly, he says that my mom tells me that my dad is no good, and that's why I'm not allowed to come around here. And that was immediately after the phone call conversation that I had called her to see if she could come pick up Tanner so there wouldn't be an issue with him staying. So she felt okay about it until the court was taken care of. And that's when the police officer came the following day. All I've been doing is trying to just be a father. I didn't know it was
Mr. Spencer, I have to interrupt for a second. What are you asking for, sir? The parenting time to be reinstated at the trailer, the camping trailer?
At my place, yes.
Well, it's a camping trailer, right?
Well, there's a little more to it than a camping trailer, yes.
Well, I'm assuming it has a hitch on it. You can pull it away if you needed to.
Yes, but there's
just a second. I'm just trying to understand you. This is not a mobile home, for instance.
Well, I've got a 400 square foot add-on with a loft and a living area, which is 10 by 20, which is 200 square foot alone.
Not talking about that. I'm talking about the original. What you claim to be the residence is a travel trailer, correct?
Yes.
How many feet is it? How long is it?
34.
34 feet. Okay. Well, that would definitely be a travel trailer. It's not a fifth wheel, correct?
No, it's a regular tow behind truck, not a fifth wheel.
And this is in a campground?
It's on my private property. I am considered recreational, residential, agriculture. It's a HOA, and there's multiple people that have campers. You're allowed to have your campers here. It's one of the only places in our area where you're allowed to have your camper and stay on your property in the area.
So you have a deed to the land?
Yes.
Okay, and you pay taxes on the property?
Every year.
Okay. Do you have Ms. Cervini, do you want her to testify?
Miss Cervini, yes.
Okay. Is she still there?
Yes.
Want to bring her in, please? Miss, would you please state your name for the record and spell your last name?
Yep, Andrea Cervini, Servieny.
And are you employed?
I am.
In what capacity?
I work for the Michigan Department of Health and Human Services in Otsego County.
And in what capacity are you?
I work for Children's Protective Services.
CPS worker, correct?
Correct.
Okay, Mr. Spencer, go ahead with your questions.
Just basically, could you just give a rundown of the place and how it's okay and safe in aspects of regarding Tanner being okay and out of harm, and just give I get just what you've seen and what you've I don't know, I'm not a lawyer, but I'm just I don't know. I can't even talk right now. I'm sorry, sir.
I can kind of explain what how I was involved, I guess, just to get a better understanding.
Go ahead.
That's fine.
So this was not my investigation. I was a courtesy worker. I had 2 home visits with Anthony Spencer at his residence. The first being on the 27th of February of last year, so 2/27/24. I was able to view the home, and although I felt it wasn't, ideal, and it's not the best situation, of course. I did not observe any safety hazards that would concern me for a 10-year-old boy. If we were talking about a toddler or a baby or something of that nature, you know, obviously they're going to be into things, but I believe that the age and development of a 10-year-old boy would know not to, you know, go into areas of the house that might not be safe for a baby. My second home visit with Anthony was on March 7th of 24. This home visit was, I guess, I was able to see more of the home. Anthony wasn't super keen on the idea of me doing a full assessment of the home on the 27th. But on the second visit, he did allow me to see the kitchen where also where Tanner sleeps and basically every area of the home. Once again, I did not see any safety concerns or health concerns. Like I said, it's not ideal. Housing up here is horribly hard, and I did understand that. So I didn't really feel that there was any concerns to be noted.
Any other questions, Mr. Spencer?
Well, there's all the safety measures that need to be in place. How many fire extinguishers did you see that I had for safety purposes? Do you remember?
I don't remember a specific number. I do believe that I did see, or you likely showed me that there was fire extinguishers.
Same with like fire detectors and CO2 carbon monoxide detectors and emergency safety exits, which there's 4 of them in the place that I live in.
Yes, I do recall seeing that.
And it was basically at the time that you seen it was over a year ago, and this was well prior to Mrs. Kruger making the 4th allegation that, you know, my camper's not safe or whatever. Just wherever it's at, it's just not a good situation, she says. And I do agree that, you know, there's a process.
You have to ask a question, sir.
Okay. Well, basically everything's up to safe. Was it warm in there? Was there running water, hot water, cold water? Ample place to, you know, privacy for him, privacy for me. Did you see all those things?
Yes, I did. I did note in my report that on the 27th of February, the first visit, it was around 60 degrees, which was unusually warm, but I don't think the heater was running, but it was very comfortable in there as far as temperature. The second time I was there back a month later, it was also a comfortable temperature. There was a functional toilet. And there was a water dispenser that I also noted in my report, which had hot and cold water. So yes, I did see his private sleeping areas as well.
And then with the toilet situation at the time, did I make you aware that we have a company called the Purple Pooper Pumper that would come out and relieve my tank, my holding tank, which I also have an extra 300-gallon holding tank that I added on, put into the ground for disposal through that same company. And go ahead.
Sorry, I do believe that you had mentioned that you had a septic company that regularly cares for the tank.
I mean, I don't know what else I need to prove to be a father, so I don't really know where else to go with the questioning on this. You know, I'm just trying to, you know, do the best I can. I know it takes a process, and I know I'm at the bottom end of the process, but my goal is to have a better place, a nicer looking place with better aesthetics.
Okay, well, that's argument, sir. We'll get to that in a bit. Okay. I'm sorry, Ms. Kruger, do you have any questions of the survey?
Yes. Ms. Cerveny, were you aware that Mr. Spencer has 6 violations in building and zoning against his property?
That is not part of what I was there to do.
So you were not aware that your county has deemed this place unsafe for him to reside in himself?
Objection, Your Honor. Objection, Your Honor. I have not seen anything in any paperwork showing that anything is unsafe by the county or any other jurisdiction. The only thing I've gotten on there was an anonymous tip that was called in multiple times by a white lady that was given to me from the zoning itself. And the only thing on the zoning is that they haven't came in to do a inspection because I never filed for a permit for anything over the size limit that is allowed to be built on the property. Anything over 200 square feet requires a permit on the property. And I have nothing on my property over 200 square feet.
Well, the objection is noted, but it's cross-examination. The question was whether she was aware. And it doesn't sound like she's aware. So the question is proper.
But yeah, the thing I just objected to is there's nothing.
Mr. Spencer, Mr. Spencer, she's alleging that. It's not offered for the truth of the matter.
All right, I'm sorry.
She asked whether she was aware. That's all the question was. Go on with your next question.
If you were aware of those violations, saying that the property was not structurally sound, would you approve this for my child to visit at?
I don't really have an answer for that.
Okay, so your answer is you're not sure if you would approve my child to go, knowing through your county that his property is not structurally safe. I just want to make sure that's the answer.
I guess it depends on if there was legal documentation with the billing or with the zoning or the health department, I would say that, there would be concerns and we would address what needs to be fixed. Yes.
Okay, well, there is. Your Child Protective Services handbook through the state of Michigan says that space heaters are not prohibited. Why is there an exception for Mr. Spencer's camper?
I'm aware of that policy. I'd have to review that.
Yeah, well, there's a handbook you have to follow. It is in there. Also, do you have proof or documentation of receipts proving that Mr. Spencer pumps his feces out of his tank? Have you received proof for any of it? Have you yourself seen any proof besides what he has told you?
My only involvement was simply to go and see the home. I was not the investigator. I did not make any decisions on the case. It was to see the home. So no,
Okay,
I did not.
guess my last question is, does Child Protective Services decide what happens to a child and define and push the law? Do you choose what is law? Or do you have someone who goes over you and orders these things? Like a judge or a supervisor, or do you make the choices on your own here on what happens to my son?
I don't make any decisions.
So you can't say yourself that my child can 100% for sure go to this camper, and you cannot say and legally force my child to go here, say it's safe. Like, you have no say. You have no authority, really. You're just here to assist families, right?
Yep.
Okay. Well, I guess that's all I have to say. She's not the law.
Ms. Cervini, I have some questions for you.
Of course.
You said your last visit was March of last year?
It was
March 7th?
March 7th of 2024.
Okay, so you've not seen this place in 2025 at all?
Nope. I don't believe we've had any requests to see his residence since the investigation was closed.
There hasn't been a complaint since Nicole has made the last complaint or the last.
Sorry, Mr. Spencer. I'm sorry, Mr. Spencer. I'm asking questions of the witness right now.
Right.
You have an opportunity to ask more if you wish to once the court is completed. Ms. Schultz, can you help me? When did the court prohibit Mr. Spencer from, or when was the motion filed, if you could help me, regarding the residence? Mr. Holt.
That was, there was a hearing that was held on December, Your Honor.
December 24th.
December 20th, 2024 was the hearing. The order entered on January 2nd, 2025, that the court had stated no visitation would happen at the 3257 residence.
Okay, thank you. All right, so Ms. Cervini, are you aware that the court ordered a prohibition of parenting time at this particular location back on, well, the order was signed January 2nd, 2025.
I was not aware of that. I was not involved whatsoever at that point.
Okay. And your inspections in February and March of last year, you can talk about last year, but you can't talk about at least December 20 moving forward, 24 moving forward, correct?
I'm only able to really say what I did, and which was on the 27th and this last year, yes.
Fair enough, fair enough. And are you assigned to Otsego County?
I am.
All right. And can you describe to the court the snowfall that was had in Otsego County this past winter?
I can say that there's been a lot. I can't tell you exactly how much. I can tell you
I'm
that
not asking how much, but would you agree there was a lot of snow?
there was a lot of snow, yes.
Was it really cold as well?
It was cold, yes.
Okay. So you can't say from January 2nd, 2024 up until today whether that camper is fit, correct?
Correct.
And regarding the water, we heard about the sewer, but the water, do you know whether the water, it comes from a well? Does it come from a water line from a municipality, or is it from a tank on the trailer? If you know.
I believe at that time he was using like bottles, like the large jugs of water, and had a dispenser.
So that would be the water that if you wanted to take a shower, you'd have, that's the water that would be used?
I believe at that time he was.
Mr. Spencer, just a moment. I'm asking the witness.
In my report, I believe, sorry, I'm just kind of looking through here. I believe what he had told me is that he uses the Airbnbs around the location that he manages, and other showers available to him, such as the public gym and other means as well to take a shower, I think is what I had reported, or I had documented.
Okay. Okay, thank you. Mr. Spencer, any more questions of your witness?
I really don't have no other questions of it, just that it was warm, insulated, food was there, all the needs that were necessary for my son are there. And she's the one that needed to verify it, along with there's 2 state officers in Nicole Kruger's report that she just talked about in court here. They also stated from both those police officers that it was safe and livable. And I've had another officer that showed up too, a county sheriff, that also asked me to do some work for him because he liked the work that I did.
Okay. All right, the court's heard enough on this motion. Ms. Cervini, you are excused. Thank you for attending. Apologize for the delay in getting your call, but we're all set. Thank you.
Thank you.
All right, this is a motion regarding modifying the parenting time order as it pertains to the minor child. The court had ordered on this at a hearing on December 20, 2024, prohibition, that is, of the child living in a camper. And that order was entered on January 2nd, 2025. The motion today filed by Mr. Spencer is asking that parenting time at the residence be reinstated because the home is fit. And the evidence that has been presented to the court, according to the witness, Ms. Cervini, is that she conducted 2 visits, February 27, 2024 and March 7, 2024, well prior to the December 20th hearing, We have nothing recent to address the issue. Anything after January 2nd, 2025 would be appropriate for the court to consider. As a result of that, the request is denied. Parenting time provision still remains in effect. And toward that extent, prior orders otherwise will remain in effect as well.
And what?
Oh, I'm also going to work one thing as well, and I'm going to make this crystal clear now. Moving forward, any future hearings amongst these parties or between these parties, both parties must appear in the courtroom. That's the only best way to handle these cases moving forward. So any motions, any hearings, witnesses can appear via Zoom if that's worked out. But anything regarding the parties, both parties must attend in the courtroom at the time.
What about the regards of Miss Kruger alienating and telling my son the things that I've mentioned in my motion here?
At this time, you can file, if you wish to file a supplemental motion to that extent, you can. I don't find a change in circumstance or proper cause. That'll be all. Thank you.
So I have nothing else to say. I can't say nothing.
You can file a motion if you wish to, sir.
I just did file the motion. I thought we were going to mention it on talk all about it today. It was all mentioned right in here.
I asked if there's anything else. The court addressed it. To show cause, Ms. Whalen is present. Court calls Hunter Jabarski. No response. Ms. McDavis, has he checked in by Zoom this morning?
Not at all, Judge.
Okay. Anything from the front of the court on this, Mr. Holman?
Your Honor, there was a order of support that was entered on April 22nd, 2024. That order had granted the parties joint legal custody and joint physical custody. The order also stated that Mr. Jabarski would have parenting time every week on Wednesday, Thursday, and Friday, or as mutually agreed by the parties. And that the parties would follow the Huron County 2022 parenting time guidelines holiday addendum, with plaintiff being parent A and defendant being parent B. The front of the court had received complaints from Ms. Whalen alleging that she has been denied parenting time and continues to be denied parenting time. The information that was attached to the motion alleges that she has been denied, my math is correct, about 30 days of missed parenting time. The dates listed in the complaint. There was also an email that was provided to the front of the court office stating that this has been going on for months, going back to July of 2024. That's my understanding. The front of the court office had emailed Ms. Whalen stating that her complaint was received, but additional information was needed with specific dates regarding that complaint. We did not hear back from Ms. Whalen. A second request was sent through email asking for the dates so the complaint could be processed. I do believe that in February of 2025, Ms. Whalen did contact us stating she could see what she could do regarding dates being provided. And I believe those are the dates that were provided and scheduled as today's show cause.
All right. And have you had any conversation or idea of where Mr. Jabarski is?
I have not. I have not spoken with the parties at all. Based upon the complaints filed and the order, with the length of time that is alleged to have been denied, that the child or children are being withheld, is what prompted the show cause for today.
All right. And you, besides filing the motion in order to show cause, there's a certificate of mailing. You mailed this to Mr. Jabarski. Mr. Jabarski, his last known address on March 5th.
Correct.
So service is proper.
And no mail has been returned to the front of the court office.
Okay. Hunter Jabarski. What are you requesting?
Failure to appear for show cause hearing, request a warrant for his arrest.
Bench warrant will be issued for his arrest. Are you requesting a bond?
I'll defer to the court on that. I guess you're on, sorry, body bond being this not a support action.
Okay. Well, make sure issue a body bond. All the court can do at this point.
Okay.
He's not here.
So, am I allowed to ask something?
Go ahead. I can't have the hearing because he's not here, but go ahead with your question.
I don't know if the council doesn't have the hearing, but what am I supposed to do about getting her to sleep it until we can proceed with this?
Do you have the child?
No,
Have you had the child?
I haven't seen her since January 9th. They won't let me FaceTime her. They won't send me pictures.
What is the parenting time schedule?
Again, Mr. Jabarski has every Wednesday, Thursday, Friday. Other than that, every week, the child would be with his waiver. So there's no specific times.
I see.
But for day purposes, this today would be this waiver.
Okay. Well, I mean, prior orders will remain in effect, which means that if it's your time, you're supposed to have the child. If you don't have the child, we'll address that once he's arrested and brought before the court. I don't know what else the court can do at this point.
That's okay.
You
I
sure?
was just wondering. And I'm wondering, I'm not sure where Mr. Jabarski resides, but I'm wondering if there were to be a court order entered allowing a specific date and time for Ms. Whalen to pick up the child, such as tomorrow morning at 10 a.m., so she could perhaps have a civil standby to assist her with that process.
Are you available?
Yes. Also, he has withheld his address from me. I never know where she is, so I don't know where he lives. Yes, I'm not sure what to do about that. We won't be able to assist with that, and she doesn't know us.
Right.
That's
Because you
fine.
can't release the addresses unless there's consent.
That's okay. I just wanted to.
Yep, prior orders will remain in effect and the court will consider that at the time we have the hearing. Sorry.
No, it's okay.
He's not here, I can't address it, but bench warrant is issued. That'll be all.
Thank you.
You're welcome. Parties are present before the court. This matter was scheduled for 9 a.m. this morning. Defendant, Mr. Jabarski, failed to appear for the hearing. Court issued a bench warrant for his arrest. And that was done later this morning, approximately 11:30, somewhere in that time frame, if I recall correctly. Court does note for the record that defendant's mother was in the courtroom, was holding up her phone. I hope she was not videotaping, but I guess we'll find out. But Mr. Jabarski is here. And Ms. Whalen, you're still under oath from the previous hearing. Mr. Jabarski, would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes. Thank you. Sir, would you please state your name?
Hunter Jabarski.
And Mr. Jabarski, you're the defendant in this matter, correct?
Mm-hmm.
Is that a yes?
Yes.
Okay, thank you. A certificate of mailing was sent to you on March 5th, 2025, advising you to appear at a hearing this morning at 9 a.m. regarding allegations of denying parenting time. Why were you not here this morning, sir?
The letter was mailed to my mom's house and she gave it to me, and I don't know if there was two papers in there. I was looking at this one that said April 23rd, so I didn't realize that I had one today also.
Well,
this is for.
So are you saying that the address that you have for your residence is not where you're living?
No, not right now. I guess not.
Okay, but I'm assuming back on March 4th, you were not living there?
No.
What is your address? Where do we send mail where it gets to you rather than to a third party?
I live in Caseville now.
Okay, can you provide that address to the court administrator after this hearing?
Mm-hmm.
Is that a yes?
Yes.
Okay. All right. Well, Mr. Holmick, you did the certificate of mailing, correct, sir?
Correct, John.
Okay. I find you contempt for failing to appear at the court hearing this morning. Is there anything you'd like to say before the court imposes disposition?
I mean, I absolutely would have been here. I wanted to resolve this. I had paperwork myself that I was going to bring in for a motion. Like, there's no reason that I would have not wanted to show up. I didn't realize that it was today.
Okay. There is You're referring to a hearing for April 23rd. That is an order to show cause for support issues, correct, Mr. Holder?
Correct, Your Honor.
But that was mailed back in February.
Correct. That was mailed out before the notice to show cause for today. Today was sent out, I believe, beginning of March.
Okay, so it wouldn't have been in the same mailing.
Correct.
Okay, so
And the home address, without going specifics, the house number is 8537.
correct, yeah.
Okay. Okay. Anything else you'd like to say before the court issues or gives disposition?
I apologize for wasting time.
Mrs. Did you have to take time off work to be here today? Yes.
No.
Your Honor?
Yes.
Can I add something?
Sure.
I guess I would ask the court to hold off on the disposition part of the contempt for the warrant, pending the other matter that was originally scheduled for today in light of information that the front of the court's been aware of since we were last in court this morning.
Any objection? Holding off on disposition for you at this point?
Disposition.
In other words, sentence for failing to appear. We would hold off on it.
Well, yeah, I would prefer that.
You prefer that? Okay. We'll hold off. We'll just tell the court.
Just for the hold off regarding the denied parent contempt show cause that was for today. I do have some concerns and questioning as to where the minor child actually is. I was made aware of some instances that happened, and thankfully the sheriff's office is very good at their job. I received a stack of police reports, and just looking through the police reports, I question where the minor child is. I've been made aware of instances of grandma taking the child from both parents.
Which grandma?
Mine.
And
Sorry.
Haley. We're back in August, Your Honor. I can give you the name here. I believe it was a Melissa Eisler O'Brien.
That would be
That's
Mr. Jabarski's.
Correct, not giving the child to either of the parents. That was back in August of 24. And the original.
This is a non-custodian. This is a grandparent. This is not a.
Correct. And the sheriff's office was called. And what makes me think about this is because of the original complaint from Ms. Whalen that she hasn't seen the child or had contact or anything since July of 2024. The dates are too close for me to be a coincidence. So I question where the child is and what exactly is going on. Along with police reports of possible eviction for Mr. Jabarski. That had happened, I believe, maybe it's the first of this year. So there's some testimony going on, but I question honestly, Your Honor, where the child is, and if there's going to be disposition on Mr. Jabarski failing to appear. Does he have the child? You know, things of that nature. So I would.
So I should find out where the child is.
I would believe that'd be best, Your Honor.
Okay. I placed him under, did I?
Yes.
Okay. Jabarski, where's the child?
She's at my mom's right now, but she's at my house, like whenever I'm not working.
Okay. How did you know about coming here today? Yes. Why is it that you showed up?
My mom was texting me and Becky was texting me.
Okay. Because your mom was in the courtroom.
Right, yeah.
So if she was in the courtroom, who had the child?
She may have went with her mom, my mom's mom, my grandma. I guess I'm not entirely sure where she was just this morning, but she's been with my mom.
Are you getting evicted out of your home?
No, that was resolved a long time ago.
Well, tell me what happened.
It was a crazy situation with the landlord, and she was like coming in the house while we were in there, and then trying to say that we owed her money, but that was all resolved.
So are you staying at the same place that you had this problem with the landlord?
No, we have a new house.
Okay, where was that house previously, the one that you had problems with the landlord?
I don't remember the exact address, or it was 51 Madison Street, Port Austin.
In Port Austin?
Yeah.
Okay. Okay. So Mr. Holbrook, I'm kind of operating at a disadvantage here. I don't know what to ask him per se.
May I say something?
You'll get a chance here in just a bit.
Okay, sorry.
Looking at this a little closer on the date of that, the possible eviction that on the report was July 5th, 24, so that would have been last year. But as stated, I'm not, just from the testimony today, where the child is at. I have allegations and complaints to our office that mom hasn't seen the child since July of last year, no way of contacting dad, no way of seeing the child, trying to get the child. I have reports that grandma of child is taking the child away from both parents. There's just, I'm kind of confused and concerned at this point.
Okay. Well, let's kind of back it up a bit. Mr. Jabarski, you heard the allegation that your mother has taken the child from both you and Ms. Whalen. Is that true?
No, that's not true, but there was one incident that he's referring to where police were called after I was trying to come pick her up after work and take her over to Lawrence. But she didn't feel like she was safe at Lawrence and didn't want me to take her.
That's your mother?
Correct, yeah.
Was that during the time the court order was entered?
Yeah, there was a court order.
So someone else is substituting the judgment of the court? That's what it sounds like.
Yeah, it was resolved though.
Well, I'm hearing allegations mother hasn't seen the child since July. Is that true?
Not since July. I think it's been maybe January.
January? Mother alleges January 17th, 18th, 19th, 20th, and 21st, as well as the 24th, 25th, 27th, 28th. January 31st, February 1st, 2nd, 3rd, 4th, 7th, 8th, 9th, 10th, 11th, 14th, 15th, 16th, 17th, 18th, 21, 22, 23, 24.
That sounds correct, yeah.
I might have messed up. Counting.
Well, that's what I'm seeing here.
So Your Honor, the original complaint came through from Ms. Whalen to the front of the court alleging there was denied parents' time in July. And when our office had asked for more specific dates and more information to process the complaint according to policy with multiple follow-ups from our director, there was nothing that was returned with dates until we got the complaint that was filed with show cause with the specific dates in January and February, which I believe totaled to about 30 over.
Okay. All right. So I'll get back to you. Miss, again, you're still under oath. When's the last time you've seen the child or had parenting time under the order?
January 9th.
January 9th.
The confusion with July was that's the first time that they started keeping her from me, and I didn't get her
Who's
back.
they?
And Hunter and his mother, Melissa. I didn't get her back until the end of August. I went back earlier and went into app close and checked. And I didn't send in dates for July until August because they ended up giving her back to me. So that was my fault. But then when they started keeping her from in January, then I sent in the complaint because it's not the first time that they've kept her from me. And even little things like him not using his parenting time and sending our daughter over to his mom.
Well, if it's his parenting time, as long as it's with a responsible adult, there's nothing the court can do about that.
No, I know. I'm saying that they are trying to take my parenting time because he isn't using his. Like there was 1 week, 3 days not a week. There's 3 days where he didn't see her once because he was too busy painting his house. And our daughter was over at his mom's, and the Friday I tried to get her, they would not give her to me, and it was at like 10 o'clock until I finally got her.
So I'm assuming, Mr. Holbrook, there's nothing in the order that says there's supposed to be a third-party custodian watching over the parenting time, custodial time, right?
Correct. The existing order is just that Mr. Jabarski would have every week on Wednesday, Thursday, Friday, or as mutually agreed by the parties, and then holidays pursuant to the front of the court holiday addendum. So there's no specific times for the exchanges, but there are days of the week that the child would be with Mr. Jabarski, and then the rest of them, the child would be with this way.
Child's how old?
I believe 3.
Yes.
Okay. Okay, so before I go back to Mr. Jabarski, what dates in January, because that's what the motion is about. You wrote in your email to the friend of the court, January 17th, 18th, 19th, 20th, 21st. Are those your days?
I don't know exactly what days those are, but I usually have her on Fridays until Wednesday. That's how we started doing it when we first got our court order last year.
Those dates do match up for those days of the week, right?
Okay.
They do run Monday to, or Friday to Tuesdays.
Also, sorry, am I allowed to talk?
Sure, go ahead.
Okay. Lonnie is not even in Huron County.
Who?
Sorry, my daughter. I didn't mean to say your name. Sorry. She's not even in Huron County.
How do you know that?
After our hearing earlier, I went out into the little conference room out there and talked to his mom. And she told me, because I asked her if she would just take me to his house to go pick her up. And she said, well, she's actually with your mom, my mom. I do not let my mom with Lonnie. My mom is not mentally stable. And so I reported it to the police. Officer Bismarck. So he lied to you when you asked him where our daughter was. She's 3 hours away.
What county, where's your mother live?
Ingham County?
Ingham, that's Lansing.
Yeah, Ingham County, Livingston. She lives in Weberville.
Weberville?
And he did know. She has been there. She didn't leave today. She's been there.
Okay.
And I knew nothing about it.
So those January dates we covered, except for Mr. Holden, 24th through the 28th. Would that also be?
Yes, all the dates she has listed, Your Honor, are consistent with the dates that would have been hers. Looking at the calendar when we had the hearing earlier today, they matched up
With the current order.
With the current order, correct. None of those dates are on a Wednesday, Thursday, Wednesday or Thursday, and that they begin on Friday.
And now we're getting voicemail messages from your mother, who must be watching this via Zoom. We have information. She sent there's a voicemail that has come to the circuit court phone.
She's watching it right now.
She was here this morning. Okay. Well, let's get to the brass tacks of it, Mr. Jabarski. Why is the child not with mom pursuant to the order?
Well, there have been many incidents where Lauren has been accused of one being on drugs, abusing medications, stealing them, being too intoxicated to take care of Lonnie. Like this whole thing kind of started when the last time that her grandma called the cops on her for one, stealing medication, and also being violent towards Lonnie. Like she was being mean and aggressive.
Well, this is the day to bring your witnesses in to testify about that. What firsthand knowledge do you have of any of that? Firsthand, not hearing from someone else, but you firsthand.
I mean, I haven't seen her recently. I haven't been around her recently, but the people directly close to her, her grandma, her entire family support me.
Okay, but no firsthand knowledge. So rather than file a motion or even an emergency motion to address this, you decided on your own to say, you know what, the hell with the court order, I'm going to do what I want, right?
I do have a motion.
No, answer my question, please. Is that true? I mean, you didn't have a court order to do this, correct?
Correct. I wouldn't say that's true, though.
Oh, no, you didn't. There's not an order in effect that says mom has parenting time or custodial time during that time frame?
There is, yeah.
There is, right. And so you, because you've heard from other people regarding these allegations, you took it upon yourself to deny mother her time, correct?
Yes. Correct.
And where's your proof right now? Other than someone saying it, where's your proof right now to say these things are happening?
I didn't have much time to prepare for this. There are police reports.
No, because we had to issue a show cause and bench warrant for your arrest.
Right.
You're held in contempt for violating the court order. So we had that issue, Mr. Holtwick. Now, specifically, you're under oath, Mr. Jabarski. Where is the child? Is the child in Weberville?
She is, yeah.
I thought you said initially it was with your mom.
I didn't realize that she already went over there, but I did know about her going.
Mr. Jabarski, you're digging a deeper hole here. I mean, I put you under oath for a reason.
She was staying at my mom's while I was working this week, and then she got picked up from there.
Will we hold off on disposition on that one too, Mr. Holtwick?
And I don't know, Your Honor. I have
never seen one like this before.
No, and yeah, I don't have any words. I'm just I have a lot of questions and a lot of concerns, I guess.
Okay. Right now, the child's supposed to be with mom, correct?
Correct. It is Friday, so child will go back to mom today. But as far as time goes, the order is mute on exchange time. So
we're going to fix
that
that
and be asked that there be a set time or time frame for visitation.
We're going to fix that. Child is being returned to mother today at 6 p.m. Period. I'm assuming, and again, I understand not wanting to give your address publicly. I get that. But you still live in Huron County?
Mm-hmm.
Is that a yes?
Yes.
Okay. Port Austin?
Caseville.
Okay, you did say Caseville. I'm sorry.
It's a pigeon address, actually.
Okay. Miss, you live where?
Kindy.
Kindy. Do you think of a midway meeting point?
For this exchange, Your Honor, I'd probably recommend Sheriff's Office.
That's what kind of sounds like to be the best. Child is being returned to mother at 6 p.m. Exchange will be at 6 p.m. Sheriff's Office. Cameras are there. Law enforcement is there. We can do a safe exchange. Prior orders will remain in effect. And this Wednesday, Thursday, Friday business regarding the custodial time with each parent. Dad has Wednesday, Thursday, Friday each week, correct, Mr. Holtwick? Correct. Wednesday at 6 p.m. to Friday at 6 p.m. We have a time. If you have an issue regarding mother's stability or any issues like that, Mr. Jabarski, file a motion, or you can ask for an emergency motion. The court took the time here to hear this case because frankly, the court could have just said, you know what? Leave the bench warrant and lien, let law enforcement pick you up, and then we could have a hearing within 3 days, possible. But that's not gonna help anyone. I don't wanna hurt you, I don't wanna hurt mom. Most importantly, I don't wanna hurt the child. So regarding, I'm regarding the parenting time that was lost, I'm ordering it to be made up. All days as alleged in the email, specifically January 17th through the 21st, January 24th through the 28th, January 31st through February 4th, February 7th through February 11th, February 14th through February 18th, February 21 through February 24. All those days are to be made up within the next 6 months, according to the policy of the friend of the court. If the parties cannot agree on it, Mr. Holbrook, how do you suggest we do it?
I would be in 30 days roughly. If they cannot agree on that, I guess my suggestion would be
bring it right back here.
Either that or until it's exercised that the weekly parenting time is alternate weeks.
Okay, we can do that.
I believe that gives about 6 days a month made up at a time.
Okay, that makes sense. In addition to the show causes here for failing to appear this morning, $100 fine will be imposed, a $50 bench warrant fee will be imposed. That must be paid by April 11th. And regarding the additional denied parenting time, other than makeup parenting time, can't find bad faith at this point. That'll be another $100 fine. Again, due by April 11th. And is there anything else I'm missing at this point, Mr. Holder?
Just you find them in contempt for line on the road. Is that you, or were you finding them in contempt for the denied parenting time?
The denied parenting time and failing to appear, those are the separate contempts.
Then I believe nothing for, I guess just for clarification, the 30-day makeup within 6 months as they agree or the alternate?
Yes.
Okay.
Yes. If they cannot agree within 14 days, then we go with the alternative. So you have to come up with a plan to make up these 30 days over the next 2 weeks. If you can't do that, then Mr. Holbrook's suggestion will be adopted by the court, which will take that time to get it made up. Now, the next thing, Dad, just a word of advice to you. Number one, you need to have a proper address where you're living with not only the clerk of the court, but with the friend of the court as well. You're always required to keep any change of address or employment up to date with the friend of the court. I would suggest you do the same thing with the clerk of the court, which you're going to do in just a moment. Next, regarding any allegations of the child being harmed, or you feel that mother's not appropriate, or whatever the situation may be, don't take the law into your own hands. That's what the court is for. That's what the friend of the court is for. And we take time whenever we can to make sure we have hearings to address this, because the child's safety is paramount to this court. But you don't take the law into your own hands, and you don't have anyone else help you do that, because frankly, as far as the court's concerned, if there are allegations that other people are taking the child and holding from both of you, that's another issue.
Yeah.
I said allegations. I said allegations. I didn't say it happened. So there are allegations of it. So that's where we go. Understand the 6 o'clock time then? And you both understand pick up and drop off at the sheriff's office. Okay. App close is ordered.
Yes.
You use it, miss? Sir, are you using it?
Yeah.
He doesn't respond to me.
Well, if he's not responding, file a motion or bring it to the front of the court. They'll address it.
Okay.
And if you can't agree, I'll address it. And it may not be too friendly for either of you. Depends on which party is not listening. Roll it.
I would just recommend that the court instruct the parties to have a civil conversation, exchange phone numbers to get app close established before they leave. And at that point, once it's established, it doesn't matter if it's blocked at that point, because app close is only point of communication.
Do you have each other's phones, numbers?
We have each other on the app close.
I'm not texting him with my actual phone number.
Yeah.
Well, do you have, is the app close working on your phone?
Yes. And we can never have a civil conversation because anytime I try, he is mean to me. And I could go back and screenshot it.
If it comes up, bring it to the front of the court's attention.
Standard communication provisions are ordered, Your Honor, negative grading comments. So if they have app close working, then that's the only way they communicate.
That's the way to communicate by app close.
With his mom holding her that one night that the police got involved, is there something that we can do about that now, or is that another file?
It's not before the court. All I know is that you were denied parenting time. I don't have any information regarding that. She's not a party to the action. However, if you want to file a motion and have it heard, the court will hear it. All I'm doing right now is addressing the issue before the court currently, and that's your denied parenting time. Because that's what was alleged. The fact that it was denied in certain other ways, it's still his responsibility. He's to follow the court rule just like you are. The court's orders, I should say. Is there any question regarding the court's orders?
No, I'm pretty well understanding of it.
Okay, sir, any questions regarding the court's orders? No, okay. I just don't want anyone coming back saying, geez, I don't understand this or I don't understand that, because we have to look out for the best interest of the child involved. That's how we'll leave it, 6 o'clock today. If the child is not provided at 6 o'clock today, contact the front of court, and then if we have to address it again, we will. And I don't want to have that problem. Let's get this thing going.
Just to place on the record, Your Honor, just to avoid any issues today at 6 o'clock, as a reminder as it's been such a period of time for the exchange, 6 o'clock is the time that our policy allows that 30-minute for emergency purposes only. So, child's coming from Ingham County, I don't know if things rise. I just want to put that on the record to get in front of any complaints coming forward that by, I don't know, 6:05, the child's not in the parking lot for exchange.
Well, maternal grandmother is already acknowledged on a voicemail message. She's watching this on YouTube. It's 2:34 right now. If she was the one involved in the transportation of it, because I don't know, there's no reason the child can't be here at 6. So the emergency provision applies when it's an emergency, period. Okay, 6 o'clock. That'll be all. Thank you.
Thank you.
Off the record.